Did Advocate Shamila Batohi just lie to the president? This is the question I found myself having after watching the Nkabinde Inquiry, and how she was busted during cross-examination that she lacks evidence against Advocate Andrew Chauke. In this video, I wanted us to talk about what happened in the Nkabinde Inquiry. As points in limine before we can begin this video, I just wanted to point out that Advocate Shamila Batohi relied on evidence, and not evidence that she collected. She relied on evidence that was given by other people, such as reports and memos from different advocates, people that are in the legal practice and people that are not even in the legal practice. Secondly, in her affidavit of the allegations that she has against Advocate Chauke, she pointed out to state capture, which has nothing to do with Advocate Chauke. And when she was asked about the intention and why did she add this thing of state capture, her defense was that no, state capture was a problem in South Africa and all of that, but it has nothing to do with Chauke. And it was put to her that she referred to the state capture because she wanted to paint Chauke as this bad person. She wanted to poison the judges that are part of this inquiry to see Advocate this evil man.
You never studied the docket, is that not correct?
That's correct. I didn't. Let me just check the time that I decided. No, that's correct. I didn't study the dockets, the 23 dockets.
Yes, I'm asking just the docket around Major General Boyseen. 2 murder charges, 1 charge of defeating the ends of justice, 2 charges of violating the Firearms Control Act. Can I tell you, Advocate Chauke read the docket. Mm-hmm. Did you know that?
I would have expected him to.
Yes. But you have come to say to the panel, there was no case against Major General Boyseen without ever having read the docket. Can I suggest that that is an astonishing proposition coming from the head of our prosecution service? And I'm going to tell the panel that at the end, that your evidence must be rejected as incredible because it is irresponsible to make such a claim without having read the docket.
It's not irresponsible at all, and I'll explain why. There's case law that national directors are not expected to read every single bit of evidence and every docket in cases, and that they are, it's perfectly acceptable for a national director to rely on reports, to rely on presentations, to request aspects of evidence, and to take decisions on that basis.
So to those ones who don't understand what is going on, so I did make a video giving out the background, but I give like a short one. So these proceedings concern Advocate Chauke, who's the Director of Public Prosecution in Gauteng. And he's been accused of interfering with the work of the KZN prosecutions, especially against General Boyseen and the Cato Manor Unit. And also he's been accused of not prosecuting Richard Mdluli, who was the head of crime intelligence at that time. And these are the allegations that he's faced with. And when it comes to Mr. Boyseen has been charged with racketeering, unaliving, defeating the ends of justice, and also contravening the Firearms Control Act. On the other side, Mr. Mdluli has been accused of corruption, unaliving, amongst many other things. There's a lot of things that Mr. Mdluli has been accused of as the head of crime intelligence. And one of the cases was the case of Vanessa Mdluli, who was unalived, and it said that. So Mr. Mdluli played a role somehow in that case. So those are the 2 cases that we're going to look at in relation to the allegations that have been raised against Mr. Chauke. The first thing that was referred to yesterday was the issue of the terms of reference. So from the terms of reference that we submitted to the president, Advocate Shamila Batohi has claimed that there is racketeering, unaliving, defeating the ends of justice, and the contravention of the Firearm Control Act against General Boyseen. And from what she submitted is that they withdrew the charge of racketeering. So in South Africa, whenever you are charged with racketeering in terms of the Organized Crime Act, it normally doesn't go in solo. It goes with other charges such as unaliving, corruption, assault, and all of those things. So now, when you remember that I told you that with the case of General Boyseen in the Cato Manor Unit, they were not only charged with racketeering, they were also charged with unaliving, defeating the ends of justice, and other cases. So when they decided to withdraw this racketeering charge, these other ones remained, right? And the question remains from the police examination as to, are you charging racketeering in connections to the others, or the others are just running in solo outside of racketeering? Because that also is possible. And she said, no, actually, when they withdrew the charges, they were supposed to withdraw everything.
Does that charge exclude the two murder charges, the one charge of defeating the ends of justice, and the two charges of violating the Firearms Control Act?
As I said, racketeering by its very nature includes the predicate offences. So it must include the predicate offences as well.
Advocate Batohi, please answer my question. I am not asking you about racketeering offences and its elements. I promise you I can read for myself. I'm asking you whether or not the independent charges of murder, the independent charges of defeating the ends of justice, and the independent charges of breaching the Firearms Control Act are included or excluded.
My answer to that is that it includes racketeering charges.
I know it includes racketeering charges because it says racketeering. I'm asking you if it excludes the charge of murder against Mr. Boyseen.
It does not exclude it in the context of racketeering.
General Boyseen should not have faced the murder charge.
Not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offences outside of racketeering.
That is where the problem resides, because Mr. Chauke, how does he get in this? Mr. Chauke is the one that says that there is evidence. These charges were never supposed to be withdrawn. Whereas on the other hand, Shamila Batohi says that there was never evidence, especially in the racketeering case, hence they had to withdraw, whereas Chauke is saying that there is evidence.
In charging Major General Boyseen with murder,
my understanding is that Major General Boysen was charged with racketeering and that those were the predicate offences.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
Yes.
I beg your pardon, Advocate Mbuyiseni. Is this question premised on the assumption that Advocate Chauke made a prosecutorial decision to charge?
Yes, I'm working now on the best case for the NPA.
That's why I'm asking the question, because all along, when we read the opening address, it seems to me that there was an issue regarding whether he made a prosecutorial decision in relation to the Cato Manor matter. My understanding of the evidence favorable to you was that Advocate Chauke was appointed merely as a coordinator in relation to the KZN Cato Manor matters.
Yes.
That's why I'm asking the question as to whether you premise this question on the assumption, at least for now, that he did make this particular prosecutorial decision as regards the charge of murder against Major General Boysen.
Indeed. I'm working now, Madam Chair, on the best case for the NPA, that Mr. Chauke has taken all of the decisions they claim. I'm trying to understand the substance of the complaint, but I will still deal with whether he did make those decisions or not. So I'm still trying to analyze the charge.
One of the biggest things that I want you to always remember whenever we talk about this case is the issue of jurisdiction. Remember that Mr. Chauke is the Director of Public Prosecution in Gauteng, and this Cato Manor situation, and General Boyseen, who was the head of the Cato Manor Unit, is in KZN. So already we're dealing with the issue of jurisdiction. How does he get the powers? And one can ask, did the NDPP at that time, which is the National Director of Public Prosecution, and at that time I think it was Ngasana, did Ngasana give Chauke the power for him to go and deal with these Cato Manor cases? How did he get to leave Gauteng and deal with the KZN cases? Where was the DPP of KZN when Chauke was interfering with the work of the prosecutions in KZN? That is not clear. And I think as the time goes by, we're still going to understand as to who actually gave Chauke the powers to go and deal with the issues in KZN, because that's one of the biggest problems of Batohi, that this man lacked jurisdiction to go and deal with these matters. So that is the first issue. This one feels like there's enough evidence to prosecute Mr. Boyseen. The other one feels there's no evidence. General Boyseen decided to take this matter to review. There was errors, there was irregularities in the process, they were not rightfully charged, all those things. He decided to review the matter. So when he took the matter to review, Chauke decided to appeal the review process. And when he appealed the review process, there were other people that were involved, including the Deputy National Director of Public Prosecution at that time, which was Jiba. Which was Advocate Jiba. And Advocate allowed the interference of Chauke because Chauke is the one that assisted the deputy to conclude an answering affidavit to the appeal process. And this is what was said, is that the finalized answering affidavit of Jiba in the Boyseen on review proceedings in opposing the review application without evidence of institution of the racketeering charges against accused. So that's what he did, Chauke. He just, kept on interfering in a way. And that's the thing. He also even concluded that the indictment, which is sort of like a charge sheet, which has all the charges, including the witnesses that will be called in those proceedings. And that was the concern, because how did he get so much power to make advocates to sign the charge sheets or, in a way, indictments? How did he get everybody to sign answering affidavit for the review processes when he's only a director of public prosecutions in Gauteng? So much influence in the prosecutorial processes of KZN. Because even Batohi said that the problem are the prosecutorial steps that were taken by Chauke. They were unlawful because there was no evidence that Mr. Boyseen or General Boyseen and the unit, they have no evidence that they can use to charge Mr. Boyseen and his unit for racketeering. So there was no evidence. But that's the thing. They also don't have evidence that actually Mr. Chauke did all of this. As I've said, they've relied on reports and memorandums from Advocate Chauke, people like Advocate Chauke. They've even relied on abstain opinions and so forth. All that shows that Mr. Chauke is guilty. But that's the thing. Advocate Batohi, which is the National Director of Public Prosecution, never did any of her own investigations. She just took what was already there from all these people and decided that she's going to submit a draft terms of reference to the president, which then informed him to dismiss Mr. Chauke. But we are finding out now that she lacks evidence. There's no evidence that Mr. Chauke has done any of this. Before I continue, I want to put it as a disclaimer. I'm not saying that Mr. Chauke is innocent. I'm just saying that Advocate Batohi lacked evidence against Chauke. Whether he's guilty or innocent, that's the thing about cross-examination. It is evidence-led. It's not what you say and what I say. If the evidence is there directing to a certain position, which is that Chauke is being sabotaged, it will look like that. So that's how this thing looks like, that they're sabotaging Chauke. And one of those arguments is that they're sabotaging him because they don't want him to be the next National Director of Public Prosecution. They want him to, just remain as the prosecutor of Gauteng, the Director of Public Prosecution in Gauteng. So that's what is the argument that is there. And this stance that is taken by Shamila Batohi is the same thing that Senzo Mchunu did. Senzo Mchunu was relying on Mary Diha's Facebook post and all of that, instead of doing his own investigation and finding out if whether the PKTT is equipped enough or not. They both of them, Senzo Mchunu and Shamila Batohi, went to the president, submitted lies to the president. And it worries me that the president never asked, but at the same time, in defense of the president trusted these people. He believes that they know what they're doing. And they don't even know. They just rely on people's reports and memorandums, people's opinions, instead of doing their own investigations. Moving right along to also the appeal, how Mr. Chauke interfered with the appeal process. So what he did is that, from what is being written here, is that there was, as I've said, that there was an appeal process. And with this appeal process, what is being said there is that he went, advised, and instructed that this appeal process continue without the approval of the NDPP, which is Mr. Ngasana at that time. And that advice was given to Advocate Holds, I think it's Holds or something, who was told that he should draft and continue with the appeal process without the NDPP knowing. And that's the thing. That process of appealing is the powers that the de facto DPP has of KZN, not Chauke. So Chauke again shows interference. And from Brownton's report, it was clear that the advocates that acted in this appeal were instructed by Chauke. So Chauke is the one that told the advocate that, no, institute this appeal process.
Dr. Broughton's report has the evidence attached to it. So I am talking about his report, which has a comprehensive dossier of evidence, which is about a lever arch, maybe more than that. I think it's a lever arch and a half full of the evidence. So I looked at documents and the evidence and not just what Dr. Broughton said.
All right. So as I understand then, again, to try and define the scope of the charge, you are saying if we read the report of Dr. Broughton, we will find there a document prepared by Advocate Chauke which instructs the lodgement of the leave to appeal.
It's not what I said.
Well, I thought that's what we've been discussing for the last 5 minutes.
We have been.
So then when I asked you to exclude the report to the minister because it came after your decision, and you said, well, look at Dr. Broughton. And I'm now asking you whether it is your evidence that Dr. Broughton has attached to his report documentary proof of an instruction from Mr. Chauke. Are we going to find it or not? Very simple.
You will not find a document of that nature.
Now let us move to the reinstatement of these charges. So, Adv Chauke then he went ahead to reinstate the racketeering charges after the charges were withdrawn. It's not clear what the reason is for him to go and reinstate these charges.
The third one is, on what basis do you say it was Advocate Chauke who attempted to have the charges reinstated? Just show me the document where he tried to do that.
I'm trying to recall the evidence of what Advocate Chauke did after Advocate Nasana was appointed. And I can't recall it at the moment, what exactly the evidence is in that regard.
You can't recall?
I can't recall what the evidence is in this regard.
Yes, I understand. But it's unfair to ask you to recall all of the evidence.
Thank you very much. I appreciate that.
I can ask you to recall at least one thing, which is, on what basis did you suggest that it was Advocate Chauke who attempted to reinstate the charges? Surely you must recall that.
I can't recall what his conduct was at that point regarding what happened when, but for the appeal aspect, I'm not sure what more Advocate Chauke did. What I do know is Mr. Nasana at some point asked Advocate Chauke, after he raised the issue of him exercising, I'm not sure how it was exactly put, but the fact that Advocate Chauke had no jurisdiction in KZN, and he then said that this matter must be dealt with by Advocate Noko.
But from what is being shown here is that there were two independent actors that interfered and reinstated these charges against General Boyseen. And that is Nasana's role and also the involvement of Chauke. Nasana, as the NDPP, still cannot just decide to reinstate without the approval or without the negotiations or conversations with the DPP of KwaZulu-Natal. But that's what they did. It seems like Nasana, from the way Batohi is presenting the evidence, that Nasana and Chauke, they were in cahoots to destroy General Boyseen. But that's the thing. From the evidence that were provided during cross-examination by Advocate Bugai Dobi, there's an email of Chauke saying that he is not going to be involved anymore in this case of the Cato Manor and General Boyseen.
Advocate Noko. That is dated the 11th of April 2014, referencing a meeting with Advocate Nasana on the 8th of April 2014, where Mr. Chauke says he will no longer participate in any manner whatsoever on Cato Manor. So surely your evidence on 3.1.1.5 must show us that after this date, Advocate Chauke attempted to have the racketeering charges reinstated.
As I said, I'm not the only witness in this matter. I don't know what the evidence is going to show.
So the question remains, how did then this decision get to be made and he be implicated when he made an email a long time ago distancing himself from all these cases. But still, there's no evidence that he actually did. The only evidence that is there is that he didn't interfere. The only evidence that is there is that he left these matters a long time ago. So this is in relation to the Cato Manor case and General Boyseen. Then we have Richard Mdluli, the former head of crime intelligence. Same Mdluli whom General Mchunu was referring to. And he said that Unatim Teto wanted him to drop the charges against Mdluli. And he believes that that was the highest form of political interference in the work of the police. And with this case also, Chauke has been accused of not charging Mr. Mdluli properly. So this one has nothing to do with the jurisdiction. It has everything to do with the proper charges that were supposed to be laid against Mdluli. So according to Chauke, there was no evidence that Mdluli actually committed the unlovings and all the charges that he's been accused of. But according to Batohi, there should be evidence against Mdluli. To a point that even cross-examination, they asked her, are you suggesting that Chauke was supposed to arrest this person without evidence? And she said, no, you need to have sufficient evidence for you to charge a person. But on the other hand, Chauke says he's found no evidence against Mdluli, but still, Shamila Batohi wanted him to charge Mdluli.
Is it your case that a prosecutor does not need to be certain about the strength of the evidence?
That's not my case. That's what Advocate Chauke says.
No, I understand that his justification is that he was uncertain. I'm asking you why he is being charged. Is he being charged because you are saying a prosecutor does not need to be certain about the evidence before they enroll a matter?
That is not the reason why he's being charged.
But what is your answer to my question? Are you saying that the prosecutor does or does not need to be certain about the evidence before they put the matter for a charge?
A prosecutor must be certain of the evidence.
Yes. Now,
perhaps Counsel Advocate Batohi, are you suggesting, as regards the evidence that is to be presented at the trial, at the state of charging, a prosecutor must be certain of all the evidence that needs to be presented to prove the charge? Is my understanding correct? Or should there be merely a prima facie evidence to institute that charge? If you can clarify that to me, or clarify your answer to Advocate Mbuyiseni
Bugai. Yes, thank you for that question. I'm not suggesting that at the point, because at that point could in fact be prima facie evidence. It could be a situation where a person has been charged because there's sufficient evidence to charge, but at that point you should be certain of that level, whether it's prima facie. You must be certain that you have sufficient basis to charge the accused at that point. It doesn't mean that it will be all the evidence, because investigations could continue and more evidence could be gathered. So, but I think the question that I was answering to Advocate Bugai Dobi was slightly different. My understanding of his question is that if a prosecutor, well, put conversely, is uncertain of the evidence, should you charge? And my answer to that was no, you should not.
And this she also got from a memorandum which was submitted by Advocate Gathali. Advocate Gathali SC, and an opinion piece from Naleni, something like that.
Correct that you relied exclusively on the memorandum by Advocate Gathali SC.
That's not correct.
What else did you rely on?
Prior to me asking for his opinion, I had received the opinion of Advocate Nalane, who recommended that this be one of the matters that be included in any referral to the President. I had Advocate Chauke's response to that in his, in the form of Advocate Maineche's opinion. I think I must just look at my letter that I sent to Advocate Chauke.
And those were some of the things that she compiled that we submitted to the President. It goes back to the title of this video and the thumbnail. Did she mislead the President? She did no work, no homework from her side. She just relied on different people and then made a decision that Mdluli is guilty. I don't know what you guys think about everything that has happened. I hope I've made you guys understand what is going on, because I've seen like some other people not understanding what is actually going on. We see, yes, Batohi is getting grilled, but what is going on? So these are the arguments that were raised from the Nkabinde Inquiry. I think that is actually guilty. It's just that Batohi lacks the evidence, because that's the thing. There is no evidence that shows that in case of all these things that I've already mentioned. But we are continuing on Thursday. We don't know what more is going to be revealed in the proceedings, but she was all over the place, Advocate Batohi. Hopefully on Thursday she'll come more prepared and she'll have her facts straight and she'll present her evidence. Nonetheless, please comment your thoughts. I will see you guys on my next upload. Bye.